Hi, everybody. My name is Tammy Berman, and I'm happy to introduce Evan Barron. We're here today to talk to you about some unique aspects of family law, specifically paternity. So here's some questions. What if I'm on the birth certificate and the child has my last name? Does that mean my paternity is established?
No, it doesn't mean it until you get a court order to determine the paternity. Now, I'm not saying that that can't be used as evidence to establish that in fact you are the father of the child, but you still need something in writing from the court order which establishes paternity so that you can have all the rights and obligations that any father would have.
So now, if that happens, does then the father go on the birth certificate? And if not, how does a father go about getting their name added to a birth certificate?
Oh yeah, if there's an order issued that declares him to be a father, yes, they will amend the birth certificate to establish him as the father of the child.
Got it. Another question, if I'm not the legal father, but I have a DNA test proving I'm the biological father, do I have any rights at all?
Well, if there's already been established a legal father in the sense that maybe the child was born during a marriage and there was someone else involved, that may be a difficult thing to be able to establish paternity with another father. Because under Florida law, if the child is born in a marriage, then those are presumed to be the parents.
Wow.
So that could be a difficult process to be able to establish that.
Got it. But
And
they
it
would have to go through a paternity action. There would have to be.
Right, and it would be much more difficult as a child gets older because the courts aren't necessarily going to declare someone else to be the dad when what you call the legal father has basically raised the child. Because again, you got to look at what's the best interest of the child and how is that going to affect the child emotionally.
Wow, got it.
It's not always that cut and dry.
So another question, is it always necessary to have DNA proof?
Not if the parties agree. Again, if the parties consent that these are the parents, then there will be no necessity for any DNA testing.
Okay, and what documents do I need to establish paternity?
Before the paternity suit is filed, you just need the agreement of the parties, basically, in a birth certificate. I mean, a lot of times the father's on the birth certificate already, and we just file that. If they don't agree right off the bat, then it's going to be a matter, again, of the DNA testing and subsequently a court order.
Got it. Based on what you're saying, it sounds like most of the time they both agree. This next question is saying, what's the likelihood I'll gain rights over my child if I file a petition to establish paternity? So how would you answer that? In most cases, they're agreeing. So,
I mean, if it's established that the dad is the dad, then he's going to have the same rights as any other dad would have under any circumstance. I mean, I don't know what those rights are going to be because every case is individual. So it's not a blanket rule and say, okay, you're the dad, you automatically get A, B, and C. You establish that you're the dad, and then the case is handled like any case would be in regards to time sharing and things of that nature.
got it. If I'm not the legal father, but I am the biological father, do I have to pay child support?
Well, the only time you have to pay child support is when there's a court order establishing your responsibility for child support. And again, unless you are found to be the father, then there's not going to be any responsibility for child support. Well, that person wants to pay anyway, that's up to the individual. But again, once paternity is established and it's established that you are the dad, then child support is going to be established. And by the way, it's not always dad paying child support. Mom pays child support too. So
yeah, that was one of our cases, wasn't it? Oh no, how did we work it in the end in our case? I can't remember. But I know that the income was far greater on the mother's side.
Right. And again, that was an example of two parties who, if they went to court, would have gotten totally different results, I believe. But the fact that they sat down together over the course of several meetings and were able to establish it. And look, neither you or I, we talked about this yesterday, we haven't heard anything from either one of them in months, which tells me that everything's going smoothly.
Yes, and you also got feedback that they made certain agreements they wanted to just change quickly before the final parenting plan was drafted, all on their own, which is wonderful.
Right. So they're working together,
Mm-hmm.
and they're taking care of their kids, and they're being, from what I know, they're being very flexible with one another, and
Yeah.
helping each other out, and that's the best thing you can hope for.
Yeah.
In going forward.
Yeah, for sure. That was a great case to see how adversarial they were. I think a big piece for them was finally having a map, a plan that was agreed upon, so that there was no discrepancy. Like, I know what I'm doing, you know what you're doing. That was a big part of their dynamics that was problematic, is just not having a roadmap together that was definitive.
Communicate.
Yeah,
They,
communication, right?
right. They couldn't communicate, and we sat there, and they did, and they both realized they basically wanted the same thing for their kids. They just were both going about it different routes until they finally figured it out together.
Yes. So just a few more questions and then we'll wrap it up. This question is it true that courts favor the mother?
No.
I feel like that's obvious answer, but maybe that's a common question that comes up.
It is a common question, and mostly it's dads that ask that. Oh, doesn't the courts favor mom?
Mm-hmm.
And the answer is no. The courts favor the children, and that's what it really comes down to. There are many cases where dad gets more time than mom does. That's because the circumstances suggest that it's in the best interest of the children that they spend more time with dad. When I first started about 100 years ago, I probably would give you a different answer, because it was generally mom had the kids most of the time and dad had every other weekend. And that was kind of established as the general rule.
Mm-hmm.
That has changed. And in most cases now, if not all, you're seeing 50-50 or very close to it.
Right.
Unless there's a reason not to. So the answer to that is no. Again, courts favor the children. And whatever's best for them. Yeah,
that's good. Once I am determined the legal father, what rights do I have? So that's time sharing, that kind of stuff pertaining to the parenting plan, or no?
Yeah, you're daddy. You have the same rights as anyone else does. And it's no different than if the parties had been married and they were going through a dissolution and determining what's best for the children. You know, one thing that every judge will tell you is their focus is always on making sure that children are protected and it's in their best interest. You know, the parties are adults. The children need to make sure that the court's there for them. Yeah. Yeah, which I've learned a lot about that being the definitive, you know, the focus is the best interest of the children. And so the case and the arguments are all around proving that to you know, for mom's case to fight versus dad's case. That's the thought process. That's the orientation and focal point of a judge, is what they're looking for, which is great if you have to do litigation. It's just that there's less opportunity to really have conversation and problem solving and work things out together, as much as it is a lack of communication and adversarial process. Positions are taken, very different than collaborative, where we're trying to support mutual interest building options. Yeah, it's amazes me sometimes how two parents, whether they were going through dissolution or paternity, that have spent many years together, just never communicated. And when they sit down in the collaborative process, they finally get to communicate and learn a lot about each other. Yeah. Which probably, if they knew that before, they wouldn't be sitting in the room with us, either for dissolution or paternity case. They've been able to work things out on their own. Yes. Okay, last questions. If I'm the biological father, but not yet the legal father, does the mother have the right to leave the country, state, county without my permission? Until it's established that they are the father through a paternity action and a court order, that father does not have the power to stop them from leaving until it's established that they are the father, and then they will be able to file whatever necessary documentation to try and stop it. And I had a case just like that where mom took off with the kids and he was never declared to be the dad. We went into court and he wanted to try and bring them back. And the judge says, well, you haven't established your paternity. So until you establish your paternity, I don't have any power to do anything, which was correct. So we had to go in and establish paternity. And by then, you know, if you wait too long and they establish a life somewhere else, it's going to be that much more difficult.
Got it. So if in your case, and that was going to be my next question, if he successfully establishes paternity, then can he make her come back, or it depends on where they're at in terms of the life they've established out of the county, country?
Yeah, I mean, unfortunately, he can't make them do anything. It'd be up to the court to determine whether or not it's in the best interest that they stay up there or come back, whatever it may be. So, but you know, it's always harder to bring somebody back as long as they haven't done it against Florida statutes and done it properly. Mm-hmm. So if there was already an established parenting plan and they're trying to relocate and they don't do it properly, file their relocation petition and try to get permission and just take off, well, that's easy to bring somebody back because they violated the law. But if they do it and there's no paternity established and there's nobody really that says that they can't, then it's much harder to bring somebody back because they haven't done anything wrong.
Got it. Is there not, if there's a parenting plan in place, this is my own question. If this happened with a client I was doing therapy with, that his family relocated. He was really on the fence. It was not agreed to in the parenting plan. She didn't go through the court. She just up and moved, and he felt kind of strong-armed in terms of dealing with that and was contemplating trying to fight for his kids to come back because they moved out of state. And what he was told was that there was a 6-month time of once they're gone for 6 months, they've kind of established a new life and you're no longer in jurisdiction. Is that correct?
Yeah, it's the Uniform Child Custody Jurisdiction Act, which establishes that once you're in a jurisdiction for 6 months, that becomes the home state of that particular child. But the question is, if they did it contrary to the law, then is there an argument that you could say, well, they established it, but they established it contrary? The reality is, if you wait 6 months, I think you are going to have a difficult,
harder time.
It may be an impossible time at that point.
Got it.
Because they can then file something in that jurisdiction to establish if nothing's been filed down here. So.
Right. Well, thank you so much for answering all these questions. And it was great having this conversation. I mean, me personally, I love talking about just sharing information about collaborative and about family law to help people better arm themselves with information and prepare for whatever their situation is. The more information that you have, the better. So I'm thankful for you including me in this.
Absolutely. Thank you. And I just think there's so many people out there that don't really understand what collaborative is. And I think the more we can educate them, the more the light bulbs are going to go off and say, wow, that sounds like something that would benefit us, what we're going through. Or some people may say, wow, I wish I would have known about that when we went through our dissolution. We could have saved a lot of money, a lot of time, and a lot of aggravation.
Right. And then they'll be the advocates for their friends that you should look into collaborative because I've heard this and it sounds really great. Try that before you go down the road of litigation.
Absolutely.
Yeah. So that part's good too.
Well, everybody stay safe.
Yes.
And hopefully we'll hear from you in the future.
Yep.
Evan Barron, my law office is in Weston. And if you have any questions about collaborative, paternity, or anything else, feel free to give us a call.
Yep. And this is Tammy Berman signing off. And if you ever have any questions from an emotional, family logistical standpoint and navigating divorce or paternity, you just want to hear an emotional perspective on the process, I'm happy to answer any questions for you as well. Goodbye.